Today, we're talking about almost every client's biggest concern: cost. In fact, when many parents receive the roster's parenting coordination agreement, the very first thing they look for isn't confidentiality, authority, or dispute resolution. It's the fee section, and that's understandable. Parenting coordination is a professional service, and parents naturally want to understand what they're paying for and why the agreement contains so many provisions about retainers, replenishment, fee allocation, interest, and payment obligations. But interestingly, the fee provisions aren't really just about money. They're actually about making sure the parenting coordination process can continue functioning when families need it most.
Let's start with the question most parents ask. Why do parenting coordinators require a retainer at all? Why can't parents simply pay invoices as they come up?
Because parenting coordination isn't usually a one-time service. The parenting coordinator may be helping a family over many months or even years. Issues often arise unexpectedly. A school problem develops. A holiday dispute appears. A medical decision needs attention. A parenting schedule requires clarification. The retainer helps ensure that resources are available when those issues arise, rather than waiting until after the work has already been performed.
Is the retainer basically a deposit?
That's a useful way to think about it. The retainer is a pool of funds maintained to support ongoing parenting coordination services. As work is completed, fees may be charged against that retainer. When the retainer decreases, the agreement may require replenishment so that the process remains properly funded.
Some parents might think, it's just a few emails. Why is there a retainer? What are parents actually paying for?
Another excellent question. Many parents think of parenting coordination only in terms of meetings. In reality, much of the work happens outside meetings. Reviewing communications, reviewing documents, speaking with professionals, preparing recommendations, writing determinations, managing scheduling issues, maintaining files, responding to urgent concerns. The parenting coordinator's work often continues long after the meeting itself ends.
Give a practical example.
Imagine a one-hour meeting about a school issue. Parents often see the meeting. What they don't necessarily see is the time spent before and after. Reviewing communications, reviewing school information, preparing for the meeting, documenting agreements, following up with necessary correspondence. The visible meeting is often only part of the overall work involved.
This confuses a lot of people. If I've already paid a retainer, why am I being asked to replenish it?
Because the retainer isn't intended to be a one-time payment. It's intended to remain available throughout the appointment. As funds are used, the balance decreases. The replenishment provisions help ensure that the parenting coordinator can continue providing services when new issues arise. Without replenishment requirements, many files would eventually reach a point where there were insufficient funds available to address new disputes.
What happens if a parent receives a replenishment request and simply ignores it?
The participation agreement allows the parenting coordinator to suspend services if required. Financial arrangements are not maintained. That provision exists because parenting coordination is a professional service. The parenting coordinator isn't required to continue providing unlimited services without adequate funding.
This may be the question most listeners care about. What if my ex refuses to contribute? Can one parent stop the process by refusing to pay?
One of the most interesting parts of the participation agreement is that it specifically addresses that issue. Many parents assume that if one parent refuses to contribute, parenting coordination automatically ends. The agreement contemplates circumstances where one parent may contribute funds that the other parent has not provided, allowing the process to continue.
Why not simply stop the process until both parents pay?
Because otherwise, a parent could potentially frustrate the process simply by refusing to fund it. Imagine a school dispute that requires prompt attention. If non-payment automatically stopped parenting coordination, one parent could effectively prevent the issue from being addressed. The agreement attempts to reduce that possibility.
I can hear some listeners thinking, wait, why should I have to pay if the other parent won't?
That's a reasonable concern. And that brings us to another important provision. The agreement doesn't automatically assume fees will always remain equally allocated regardless of circumstances.
Most parents assume parenting coordination costs are always shared equally. Isn't that correct? And
Not necessarily. Many appointments begin on a shared cost arrangement. However, the participation agreement allows fee reallocation in appropriate circumstances.
explain that because many people have never heard the term before.
Fee reallocation recognizes that some conduct may create substantially more work than other conduct. For example, repeated unnecessary disputes, excessive reporting, failure to provide requested information, repeated cancellations, conduct that generates avoidable expense. The agreement allows for the possibility that responsibility for fees may be allocated differently where appropriate.
Some parents will hear that and think it sounds like punishment.
The purpose isn't punishment. The purpose is fairness and cost allocation. The question is not, who deserves to be punished? The question is, who generated the work that created the expense? Those are very different questions.
Let's talk about another clause parents often notice. Why does the agreement mention interest?
Because parenting coordination sometimes involves ongoing services and accounts. The agreement contemplates interest on overdue accounts. The goal is to encourage timely payment and to address situations where accounts remain outstanding for extended periods.
Here's something I didn't appreciate until reading the agreement. What happens if somebody drags the parenting coordinator into court?
That can significantly increase costs. If the parenting coordinator is required to review records, respond to subpoenas, attend court, prepare documents, or participate in legal proceedings, additional professional time may be required. The agreement specifically anticipates those possibilities.
After years of practice, what's the biggest misunderstanding parents have about the fee section?
The belief that the fee section is only about billing. It's actually about maintaining a functioning dispute resolution process. Almost every financial provision exists because parenting coordination can't help families if the process continually runs out of resources. The retainer provisions, replenishment provisions, and funding provisions are really process management provisions disguised as financial provisions.
So what's today's main lesson?
The fee section isn't simply about collecting money. It's about ensuring that parenting coordination remains available when disputes arise. The agreement recognizes a practical reality. If families need assistance, the process must remain funded well enough to function.
Today's conversation explains why the financial provisions are much more important than many parents realize. They're not just accounting rules. They're part of the structure that keeps parenting coordination operational.
Exactly. And once parents understand that connection, the retainer provisions usually make much more sense.
Next, we're going to tackle another question many parents quietly wonder about. What if I don't like my parenting coordinator? Can I fire them? Can they withdraw? Can I make a complaint? And what happens if I think the parenting coordinator got it wrong?